All right, let's talk about this with Page Pate, CNN legal analyst and criminal defense attorney. We also have a couple other things to discuss here besides Michael Cohen. But first and foremost, this day, it's just a stay. It's essentially hitting the pause button. With that said, how vulnerable is the president still to a deposition in this case, which is what Michael Avenatti wants to do?
Right. Well, I think eventually the president is very likely to be deposed in this case. But what the judge has done is said, look, I'm going to stop the civil case because you may be facing criminal charges, and saying that you're going to take the fifth here, I don't think it's a delay tactic. I think you have serious exposure. So I want you to be able to answer the questions that are being raised in the civil case, but you can't do that while you may be under criminal investigation in New York. So let's stop everything for 90 days, see what happens in the New York situation, then we'll revisit the issue.
But you're saying President Trump most likely will have to sit down for a deposition.
I think so. I mean, listen to the statements that he's made, that Cohen has made about whether or not he was even aware of this deal, whether Cohen was representing him in connection with this deal. There's a lot of factual information that can only come from the president about whether or not he was involved in this agreement with Ms. Daniels and whether or not Cohen was representing his interest when they agreed to the payment. So, yes, he's a fact witness and a very important one.
Michael Avenatti, Stormy Daniels' attorney, had something to say about this yesterday. Let's listen.
If this was only about 90 days, I don't think we'd be taking it up on appeal. I mean, we might, but we're concerned about it being delayed beyond that. My client continues to fall under this NDA. According to the defendants, they continue to threaten her with additional millions of dollars in damages. She wants to be clear of this, and she wants the defamation claim against Michael Cohen fully adjudicated.
He says they continue to threaten her, Stormy Daniels, with millions of dollars in damages. Should Avenatti be a little more forthcoming about what these threats are, and does it really affect this 90-day stay?
It doesn't. And there aren't any express threats. I mean, that's just their position in the lawsuit. Okay. Cohen and Trump are saying, look, you know, you violated this agreement. You're going to owe us a bunch of money if you have this money.
But she's still talking.
Absolutely. That hasn't stopped her. Obviously, she's giving interviews, her lawyers talking about this case everywhere, any opportunity he can get. And I think that may have kind of ticked off this judge. I mean, the judge sees this case being used for political purposes, publicity purposes. I think that may be another reason why he said, look, let's just stop it for a minute. Okay,
I want to get to the Texas voter ID laws here. Fifth Circuit Court of Appeals voted to uphold the Texas voter ID law. It's SB 5. Critics say that it suppresses votes. I want to read here something from a sheriff in Texas, Lupe Valdez. She's running for governor of Texas. She says, disappointing setback to see Texas's discriminatory voter ID law upheld. We should be making it easier for eligible Texans to vote, not harder. Is there a chance that this could turn around again in Texas? Because they're vowing to fight.
Right. It's possible. This case has gone up to the Court of Appeals, the Fifth Circuit Court of Appeals, a pretty conservative court, especially now with the recent Trump appointees. The panel, it's a 3-judge panel, decided this one's okay. The first law was really bad, but this one we're going to let stay. The plaintiffs can appeal that decision because that's just a panel of 3 judges. They can take it to the whole court. Okay. But given these conservative judges, I think this particular law is going to stay on the books.
A lot of people, I think, were surprised by what happened with Bill Cosby this week. Were you?
Absolutely.
You were. Okay.
Yes.
So found guilty on 3 counts of sexual assault, essentially. This is a man who's 80 years old. The judge released him, didn't remand him into custody immediately, saying, look, he's 80 and he's complied. He's shown up for every court, every court hearing. Based on what we know about this, is that protocol when you have somebody who is convicted for the crimes that he has been convicted of?
No, it's not protocol at all. I mean, he's been convicted of serious sexual assault charges. Once that happens, you normally go to jail. And then sentencing can come later. We don't know what the length of the sentence will be. Very unusual because the conditions for bond, I mean, talking about showing up to court, you're not a flight risk, that's the analysis before you're guilty. Right. But once you're guilty, the presumption is you go into custody. So what the judge may be saying is, yeah, he's old, he may not be well, they've got an appeal, I may let him sit out while this appeal is pending.
That appeal could take years.
It could take years. But what I think the judge is really saying here is, I listened to this evidence. Maybe I'm not 100% sure that he did it.
All right.
Because it's not
the judge
normal.
may not agree with the jury is what you're saying. Yeah. All right. Which will be interesting to see what happens then in sentencing.
Right.
All right. Very good. Page Pate, always appreciate your insight.
Thank you, Christi.
Thank you.